Good to go? How's it sound? Okay. All right. Great. Good afternoon, everyone. Up here with me today, let me introduce folks. My Chief Deputy Fadwa Hammoud, Chief of the Criminal Justice Bureau Danielle Hageman Clark, Assistant Attorneys General Gage Wakula, Kayla Carino, and Bill Ralston. What else do we have up here? We have Aubrey Sargent from our Investigations Bureau. And I think we've got everybody else. Sorry for the wait. Whenever we have charges that we issue, obviously we have to wait for the court to sign off on it. And we do our best to estimate how long that will take, but we don't always know. So again, my apologies for the delay. We are here today to announce that my department has charged Anne and Robert Minard for their role in misappropriating funds from numerous legal entities, including 501c4 social welfare nonprofit organizations, multiple state campaign committees, an independent political action committee, an advocacy group, and a lobbying firm. We allege that the Minards financially exploited and/or defrauded these entities through a sophisticated pattern of improper reimbursements, double billing, misrepresenting expenses, and falsifying records. In addition, we are alleging that Anne and Rob Minard falsely reported their 2020 adjusted gross income on their Michigan state tax filing. The Minards are a married couple who previously worked as senior staff and advisors for former Speaker of the House, Lee Chatfield. Anne Minard served as Speaker Chatfield's Director of External Affairs and Rob as his Chief of Staff. In these roles, the Minards had access to a vast network of well-funded nonprofit, corporate, and political groups which were tied to the Speaker's political activities. The Minards concurrently owned and operated a political consulting firm named Victor Strategies while serving as state employees. This consulting firm served as a tool for the Minards to contract with many of the above-referenced entities and earn fees while consulting, fundraising, and coordinating campaign activities on behalf of then Speaker Chatfield. The Minards held leadership roles in both the House of Representatives and their independent consulting firm. They are Lansing power brokers who choose their clients and undertakings and who boast tremendous access in the realms of government and campaign politics, and have the ability to sway public policy, political strategy, and have demonstrated high aptitudes for campaign fundraising. And the evidence uncovered to date supports allegations that the Minards use these professional contractual relationships to financially enrich themselves in a way not permissible within the law. And we allege today that the Minards wrongfully embezzled, misappropriated, or wrongfully obtained a sum of at least $525,000 just from the years 2018 to 2020. And this is important to note because at the same time, between the work that they did, the taxpayer-funded jobs that they held, and Victor Strategies, the other work that they were doing legally had made approximately $1.5 million during that time period. But this is an additional $525,000 that we allege was not obtained legally. So consequently, Anne and Rob Minard have each been charged as follows. One count of conducting a criminal enterprise, a 20-year felony. One count of conspiracy to conduct a criminal enterprise, a 20-year felony. 3 counts of false pretenses, 1,000 or more but less than 20,000, 5-year felonies. 1 count of false pretenses, 20,000 or more, less than $50,000, a 15-year felony. 1 count of embezzlement, $100,000 or more, 20-year felony, and 1 count of filing a false tax return, which is a 5-year felony. In addition, Anne Minard has been charged individually with 2 counts of embezzlement, 1,000 or more but less than 20,000 from a nonprofit or charitable organization, a 10-year felony, and 2 counts of false pretenses, 1,000 or more but less than 20,000 each, 5-year felonies. Rob Minard has also been charged individually with an additional count of false pretenses, 1,000 or more but less than 20,000, a 5-year felony. Now, I'd like to spend a minute discussing the elements required for each of these charges, with the understanding, of course, that both Anne and Rob Minard are presumed innocent until and unless proven guilty in a court of law. First, that the defendants used a pretense. A pretense is defined as knowingly making someone else believe something that is false, or keeping someone else from finding out important information about the property involved. Second, that the defendant knew that the pretense was false at the time they used it, that they intended to defraud or cheat someone, and that they used something of value. We must also prove that the money or property belonged to the nonprofit organizations, that the defendant had a relationship of trust with the nonprofit due to their role on the board or campaign, and that they obtained possession or control of the money or property because of that relationship. And finally, that the defendants converted the money or property to their own use and did so with the intent to defraud or cheat the nonprofit of property. Do we have an arraignment date yet? Okay. This is in the 54B District Court. My understanding it's been authorized by Judge Molly Hennessy Greenwald, and hopefully we'll have that information shortly as to any potential arraignment dates. Now, these charges come on the heels of a nearly 2-year-long investigation that began with criminal referral from Michigan State Police regarding allegations made against the Minard's former employer, former Speaker of the House, Lee Chatfield. Now, although the initial referral did not pertain to the Minards specifically, as the investigative team continued to uncover and review evidence, it became very apparent that they were intimately involved in a massive amount of financial misappropriation. However, I want to be clear, this investigation remains ongoing, and the Department of Attorney General has not finalized charging decisions in all aspects of the investigation, and that includes our review of any conduct involving former Speaker Chatfield. Now, I understand that I've expressed both publicly and directly to some of you in this very room our intention and our ambition to have this investigation concluded by the end of this year. This case, as you know, is one of many public integrity investigations that my department has been handling, and I believe it's inherent to the public good to set some sort of expectations on when a conclusion can be anticipated. But unfortunately, due to the voluminous amounts of evidence discovered that included millions of documents, emails, records, pieces of data, and procedural rules on gathering the massive number of documents we've received, the investigation cannot conclude by year's end as it pertains to all the individuals involved. I don't like to fall short of any public declarations of intent, but we do have a responsibility to conduct the very best investigation we can for the people of this state, and that investigation must continue. The evidence demands it. And while we're nearing an endpoint, to provide the people a thorough, comprehensive investigation and a sound prosecution, more work must be done, and so it will be. The Michigan State Police initial referral to my department was in 2022. It was complex, wide-reaching, and involved many players and a variety of offenses. And as simple as the allegations might sometimes appear in media reporting, the investigation really has been very far from simple. And today, these charges against these two individuals, now defendants in the state prosecution, represent not where we've ended, but where we began. Now I'd like to turn briefly to discuss the substance of the charges against Anne and Rob Minard. Now, as noted, there are numerous legal entities involved, and those include the following. The 501c4 nonprofits were the Peninsula Fund, Make Michigan First, and Protecting Michigan Future Fund. Also involved the following campaign committees: Julie Alexander for state rep, and Friends of Jim Lilly, and also the independent PAC Working Together for a Better Michigan. And we have charged the Minards with misappropriations from or misrepresentations made to each of these named entities. During the investigation, it became clear that there were substantial amounts of money involved with these entities that we alleged was handled improperly by the Minards. Now, some of these allegations include the following. submitting invoices to nonprofits for personal reimbursement that showed expenses they did not personally incur or that they did not incur fully, such as by means of presenting estimated expenses, representing them as final bills for sums that were larger than the actual expenses, or by requesting personal reimbursement for expenses incurred by other nonprofit or business accounts, unilaterally moving funds from nonprofit accounts without proper justification to their own accounts, and documenting misrepresented invoices without approval from nonprofit administrators, misrepresenting expense forms, unilaterally using nonprofit funds to pay their own personal expenses, contrary to provided documentation of personal versus business expenses, or even absent documentation altogether. Receiving and keeping for personal gain reimbursement funds from outside entities intended for receipt by a nonprofit, which actually incurred the expense. Invoicing a nonprofit seeking and obtaining reimbursement for costs not incurred by the Minards, but already paid by the nonprofit. Converting nonprofit funds intended for a specific purpose to unrelated and unauthorized business expenses of their private consulting firm, for which separate outside clients had already been paid or had already paid them, and otherwise misappropriating money in their legal possession and then converting that to their own personal use. The terms embezzlement and false pretenses are simple enough to understand. It's taking what is not yours and misrepresenting facts to wrongfully obtain that which is not yours. But the methods and the scheme alleged today are far from simple or easy to follow. So our investigators and prosecutors have worked so diligently for nearly 2 years to uncover what was going on, which included the untangling of tens of thousands of financial records, receipts, emails, and years of communications between Lansing power brokers and hired gun functionaries who often acted like bought and paid for rubber stamps. We've additionally interviewed dozens and dozens of witnesses and interested parties. Just to sort of allow everyone to understand why this is such a time-consuming process, for every financial institution we executed a subpoena on, statutorily they are entitled to 90 days to respond, and then when that information leads us to another financial institution, the clock starts over, and so on. We also used a taint team throughout the course of this investigation and erected an isolation wall separating the reviewing teams from the investigating divisions. And the taint team has received potentially privileged documents uncovered throughout the investigation and reviewed them to determine whether or not they're subject to attorney-client privilege. The taint team procedure ensures that the attorney-client privilege of anyone subject to our investigation is preserved, while still allowing our investigators to review documents that are not subject to privilege. And that review process is not complete, and I anticipate our investigators will receive thousands of more documents before all is said and done here. And with that, I really want to thank AAG Gage Wakula and our special agent, Bob Minard, no relation, who worked tirelessly on this case and reviewed an unknown number of documents and have done really an outstanding job of going through all this. So thank you so much, Gage and Bob, wherever you are. So one striking conclusion discovered early on in this effort was this. Of course, these alleged crimes were likely to occur. The environment of money, influence, power, and the feeble regulation in place, the ineffectual reporting standards, the sheer volume of transactions, the staggering sums of money can all too easily become vulnerable to fraudsters, to con men, and con women. And today, we're alleging that that is exactly what the Minards did. Political fundraising and spending by those who follow and flout the rules alike has for far too long remained in the dark and hidden away from Michigan residents and from law enforcement. Now, I'd like to be clear about the types of social welfare nonprofits we're discussing today. These types of nonprofits are not giving charitable gifts to sick children or communities in need. They are functional conduits of dark money campaign donors that can accept unlimited contributions from corporations without publicly disclosing their donors. Their social welfare amounts to expensive, politicized speech that is careful to fall just short of endorsing specific candidates. And these funds are more accurately characterized as campaign war chests than anything having to do with social welfare and activity similar to the types of nonprofits those watching at home might donate to. These nonprofits are not required to pay taxes, and they are not required to publicly disclose their donors. And it is so easy to raise massive amounts of money, and there are very few rules on how this money can be spent. And that's exactly why they're utilized as dark money vehicles in political campaigns. It's flagrant, it's blatant, and it's obvious, but only when someone has the ability to review it. Our charges represent what we believe we can prove well beyond a reasonable doubt based on the limited statutes available to us. Statutes that in principle aim to curb illegal and unethical behavior. And we intend to prove that this was not an accounting error, this was not an oversight, this was instead a repeated pattern of illegal activity. As our investigation and prosecution remains active and ongoing, there's not a lot more that I'm able to disclose publicly about the alleged schemes for which my department is charging Ann and Rob Minard. The methods employed to embezzle, misappropriate, receive, steal from these accounts are complex, and it remains difficult sometimes until evidentiary elements are exhibited in open court before a judge and to the public to fully and fairly illustrate the orchestrated flow of nonprofit funds into the private accounts of the Minards. But that is precisely what we've alleged and charged, and that is what we intend to prove in open court. Our investigation will continue full steam on its own timeline to ensure thoroughness, precision, and appropriate care and attention to due process. I do anticipate meeting you all here again in the next few months with further charging decisions and further fruits of our investigative efforts. But again, it is the evidence that will have the ultimate say regarding the timeline. But there is one congruent running theme as we move through these complex cases, and that is, of course, Michigan's campaign finance and political disclosure laws and how they lack clarity, they lack transparency, they lack teeth. It is the weakness of these laws that has made it so easy for people with ties to our government representatives and big money donors alike to skirt the system for personal benefit while also skirting any legal responsibility for their bad behavior. And we allege that the Minards took full advantage of that. These are concrete abuses in black and white, so much so that in some instances, it's obvious that they were counting on the fact that no one would ever review it. Without probable cause to review the internal documents in this case, having a referral from the Michigan State Police, it's likely the public would never see what happened to any of this money. With today's charges, we allege that Ann and Rob Minard didn't just skirt around Michigan's anemic regulation of political spending, but knowingly, willfully, and overtly violated the law for their own personal enrichment. And we intend to prove again that this was no accounting error, but a repeated pattern of illegal activity, a continuing criminal enterprise. And under the shade allowed through Michigan's current campaign finance laws, the Minards hid under the guise of the business of fundraising to repeatedly embezzle money from nonprofits directly, as well as by misappropriating those funds into their own accounts. Michigan residents deserve more. They deserve better than what this flawed system has allowed. As my teams work these investigations, we're also meeting with the legislative work groups that have been formed to analyze and improve Michigan's campaign finance laws. And at the conclusion of these investigations, I will also be sharing very specific legislative recommendations to place additional sunshine on political fundraising and spending and to make it more difficult for future bad actors to engage in these types of activities for their own personal enrichment. And again, I'd like to reiterate that today's announcement is not the conclusion of this or necessarily any other major public integrity investigation, but the first step in what I hope will lead to not just accountability for those who violate our laws, but a massive culture shift away from the way Lansing currently operates in the dark into what I hope will be a fully transparent and accountable system. So thank you, and with that, happy to take some questions.